All right, let's get to our last discussion of the day now.
Fewer than 4,000 voters will determine the next governor of Osun State on Thursday. And that's the new day the Independent National Electoral Commission has fixed for a runoff vote after declaring Saturday's election inconclusive.
All right, no candidate was declared winner because there were more cancelled votes than the margin between the top two candidates. Only registered voters at the polling units where votes were cancelled will vote in the rerun, and all 48 political parties will take part in the runoff exercise.
So the total number of registered voters at the polling units where elections were cancelled is 3,498. We will recall that early this morning, we presented reasons why a candidate could be returned or candidate may not be returned. The margin, according to the election guideline, where the margin of win between two leading candidates is not in excess of the total number of registered voters of the polling units where elections were cancelled, a candidate or a party may not be returned.
But that decision by INEC has sparked debates across board in the country. Same scenario played out in the recent Lokoja Kogi Federal Constituency by-election, where APC polled 26,860 votes and the PDP polled 14,845 votes. The margin of victory in that by-election, 12,000 votes, while 19,000 votes thereabout were voided. But still the APC was declared winner of that vote.
Yeah, how different is that scenario from the Osun poll? What are the legal implications and the political implications of INEC's decision? These are some of the issues we'll be looking at next, because those are the issues that form the debate on the streets.
That's right.
In Osun and even in Nigeria, even from legal practitioners and lawyers. We have joining us in the studio a lawyer and a human rights activist as well, Inibehe Efyong. Good morning.
Thank you for having me.
It's nice to have you join us.
Thank you.
Yes. There has been, the rest of us that are not lawyers, we sit down keenly, listen to lawyers, argue it out as to INEC did the right thing, no, INEC didn't do the right thing, and all of that. And then at the end of the day, we become even more confused. And that's how confused Nigerians are as to whether INEC, in declaring the Osun election inconclusive, was on track, or whether it wasn't on track. Make us understand.
There need not be convergence of opinion among legal practitioners on controversial issues for there to be certainty on the law. Lawyers will always differ on issues of law, but we know as lawyers that there are certain points that are settled by judicial precedents that the courts have made pronouncements on. And on such issues, no matter the argument proffered, no matter the contention, no matter the points canvassed on both sides, the law remains the law. On the Osun election, I want to start by saying that the constitutional basis for making a return or deeming a candidate to be victorious or declaring a winner in an election is as contained in section 179 of the Constitution, subsection 2, which principally enshrines two requirements, namely that for a candidate to be declared and a return made by INEC, the candidate should satisfy the following conditions. He must score the majority of lawful votes cast at the election.
Majority.
He must also secure 1/4 of the votes in at least 2/3 of the local government areas in the state. In Osun, where we have 30 local governments, it means a candidate has to secure 25% votes in at least 20 local government areas. both the candidate of the APC, Oyetola, and the PDP candidate, Adeleke, apparently satisfied this requirement, except that for the first requirement, it is Adeleke who had the majority of lawful votes. Mm-hmm. That is why some persons, including the party, the PDP, are saying, no, having met this requirement, why do you have to declare the election inconclusive? Mm-hmm. That the election is conclusive, the election is concluded. But that is not the end of the matter, because the Constitution is not the only source of law for the conduct of election. The constitutional provisions is supplemented by the Electoral Act 2010 as amended, the guidelines, regulations, and manuals issued by INEC pursuant to the powers granted it by Section 153 of the Electoral Act. And the Supreme Court has held, as far back as 2011, in the case of Congress of Progressive Change, CPC, and INEC, that INEC is bound by the Constitution, the Electoral Act, the guidelines, regulations, and manuals issued for the conduct of elections. So Nigerians who are arguing about conflict between the Constitution and INEC guidelines needs to know that the conflict does not relate to substance, because what Section 179 of the Constitution envisages is better understood by reference to the Electoral Act and the guidelines of INEC. More so that the highest court of the land has validated these guidelines. What does it say? That in an election where the margin of win between the two leading candidates is not in excess of the total number of registered voters. That's right. In polling units where elections were cancelled, INEC is given the discretion or maybe an obligation to reschedule election, not make a return, and hold a rerun. In the case of Osun, we have a situation where 7 polling units spread across 4 local government areas of Orulu, Ife North, Ife South, and of course Osogbo, where election, properly so-called, did not take place. In Ife North, for example, you have a case of overvoting, where the votes purportedly cast during the election is in excess of the number of registered voters. INEC had no choice, because by virtue of Section 53 of the Electoral Act, INEC must cancel those, nullify those votes, and set a date for another election where the number of registered voters in the polling units where overvoting took place would have made a difference in the election.
I was almost going to say that you have left me more confused than we began. But I think I understand your point of view now, that the electoral guideline and the decision INEC has made is in consonance with the law. But then reference is being made to what transpired in Kogi State, where in a by-election, the margin between the two contenders, the two top contenders, was in the excess of 12,000, and the nullified votes was in the excess of 19,000 votes, and yet a winner was declared. Are you saying categorically now that INEC erred in the previous in its previous verdict?
2 points. The first is that if there is a strong argument supported by facts that INEC hasn't been consistent on the policy of declaring election conclusive or inconclusive, it is legitimate. People have the right to be aggrieved and to call the integrity of the commission to question. I don't have the details of the 19,000 votes in the Kogi by-election, because let us not mix the concept. Some Nigerians have gotten it wrong. What we are discussing in Osun is not void votes, it's not invalid votes. We are discussing council election in polling units. A vote can be voided if, for example, a voter does not clearly indicate who is voting for between PDP and APC. For example, if his thumb falls in the ballot paper between the two candidates, that vote can be voided. For example, if you have a voter who does not even bother to tick, but just dump the ballot paper in the ballot box, such votes, recognizance is not hard to them in counting. Those are void votes. Aren't
those words interchangeably used? If votes were cancelled, that means the vote in that region is invalid.
No, if votes are cancelled in a polling unit, it is vote that is cancelled. But results will still be announced for that polling unit. It is different when no results or the entire result is completely cancelled, in which case you cannot say who won in that polling unit. That is what has happened in Osun State.
All right.
So in those 7 polling units, nobody can say I won. For example, you have a polling unit where the presiding officer ran away. You had 2 polling units where the card reader malfunctioned.
Yeah, exactly.
You can't disenfranchise people. That will even be the constitutional basis to launch a challenge at the tribunal on the basis of disenfranchisement.
And somewhere in Osogbo where election did not even take place
Exactly.
at all.
And even a polling unit where there was disruption. So INEC had the basis in law to say, let us go back for a rerun.
Okay. Now, let us, in considering all of this, dimensions, is it discretionary too on INEC that it could have declared the election or declared the winner? If INEC had gone ahead to declare a winner, would it have aired?
It would not.
Wow.
That's my position. It will not.
Wow.
Because the manual first is made by INEC. The regulations relied on to declare the election is issued by INEC. It is not a constitutional requirement. Once the constitutional requirements are satisfied, INEC can go ahead to declare a winner. But there could be implications.
Now, Mike, I am confused.
No.
That is why we are calling for consistency of policy.
Okay.
If you are going to be declaring election inconclusive with these parameters that I've highlighted are not satisfied, you have to be consistent. Even the Electoral Act, Section 69, the reference has been made to, where INEC can look at the margin and say, let us go back. It used may, not shall. May is discretionary. So INEC has that discretion, looking at the circumstance in a particular case. But I am insisting that it should be consistent. The point is that no matter what we say, like when PDP said they are going to court, I welcome it. It will enrich our jurisprudence. But I can beat my chest to say that the Supreme Court has resolved this case in Adeleke's case. The case of Adeleke versus INEC and others just decided in the Kogi election, where you have Prince Abubakar Adu.
Faleke.
Yes, Faleke.
Yeah.
You had Prince Abubakar Adu, who before he died, ran with Faleke, and you had Idris Wada of the PDP. You are aware that in that election, the Abubakar Adu had already secured majority of votes before he died. So, Wolelari Pekun, SAN, who some describe as the god of election petition in Nigeria, went to the tribunal to argue that as at the time INEC declared the election inconclusive, the election had been concluded, the winner had emerged. The constitutional requirement in section 179 had been satisfied. He lost that argument at the tribunal. He lost that argument at the Court of Appeal. He lost that argument at the Supreme Court.
That exactly is the point I'm making, that there can be no credible democracy, right, without credible elections. And there can be no credible elections without a credible legal framework, which includes judicial interpretation of constitution as well as statutory provisions. Now, if what you are saying now is that a Supreme Court has already made a verdict, and you're also saying in another breath that if INEC had announced a winner in the just concluded election, it would have been correct. Would you say that indeed we have a legal framework upon which our electoral processes, are based on in this part of the world?
It is a legislative problem. It is a problem that should be resolved by legislation. That is why the National Assembly should respond to this. Let the National Assembly amend the Electoral Act and even the Constitution to give certainty on these issues. Because I agree with the lawyer that even the courts, haven't been too consistent on this issue. For example, we had a situation where some Court of Appeal divisions disagreed with this principle of inconclusive election. But as I have said, the Supreme Court has decided. In Kogi, you had 91 polling units where elections were cancelled. And the Supreme Court said INEC had the right to declare the election inconclusive. I'm saying that when you look at the margin, and you know that if election is conducted in those polling units, it will have effect on the election. There is a basis for INEC to do a rerun. But if INEC had declared the election conclusive, I seriously doubt if that election would have been invalidated. Because what is vested in INEC is not an obligation, it is a discretion. The language of the law is may, and every lawyer knows may is directory, may is discretionary. It is not compulsive. Because you had a winner who had majority of lawful votes. You also had someone who had scored the geographical spread in the election. So I believe they could have gone ahead.
So we are leaving the result of an election to the discretion of an individual, doesn't that make that organization susceptible to, you know, being manipulated by politicians?
Which is why the National Assembly should respond to this. It is a legislative problem. You can't really blame the courts so much. It is a legislative problem. Because I know that disenfranchisement is wrong. What even led to the guidelines? You had a situation where before this guideline in 2015 was issued, politicians would go to the strong base of the opponents and disrupt election, disenfranchise Nigerians from voting. INEC now intervened. What INEC did was to respond to a mischief of disenfranchisement of eligible voters, to say that once people are disenfranchised by reason of corrupt practices, by reason of disruption of election, they will now postpone election and reschedule election in those affected areas.
All right, so based on the because you said that INEC is meant or should be consistent, so that there is no confusion. So based on this inconsistency, because if we cite the case of Falike, like you said, in the case of, Falike, like you said, in Kogi State, on one hand, cite the outcome of the House of Rep by-election in Kogi State that happened earlier in the year on the other hand, and then Osun, it means that there are inconsistencies. It means INEC is contributing to the confusion on ground right now.
That's why,
based on the discretion, the powers of the discretion the Constitution has given them.
Which is why some of us are calling on the Commission, because in election, as an electoral umpire, integrity and perception is everything. This point has been raised. One would have expected the Commission to issue a statement to clarify it, to distinguish if there is any distinction between what happened in the by-election in Kogi State and what we have witnessed in Osun. There shouldn't be discretion. Let the law be amended for us to have certainty, for there to be certitude on what should happen when you have this kind of scenario. INEC shouldn't have a discretion. If you have polling units where election does not take place and the margin is not significant, if we are going to declare winners, so be it. If there is going to be a rerun, so be it. But let it be clearly stated in the law. There shouldn't be basis to give discretion to INEC. But I've made the point that no matter the argument we profess, the Supreme Court has upheld that discretion. The Supreme Court has upheld the manual and the regulations issued by INEC.
And so this gives us loopholes that politicians can take advantage of. It also means that beyond all the hula baloo about improving our electoral process, we celebrated INEC, 98% in arrival of electoral materials. There were places where, you know, electoral officers were there as at 6:30 a.m. in the morning. It means that all of this is just one part of the process. And then there's also the issue where if elections, you know, or voting are cancelled in an area, then it can disrupt the whole, you know, process. The big question now is, how do we ensure that politicians don't take advantage of this? Because we are not likely going to solve this issue before 2019.
It is not, in as much as we admonish INEC, to their credit. Part of the reason why I commend the decision of INEC to declare this election inconclusive is that in 2 polling units, the smart card readers were not functioning. I commend INEC for rescheduling the election, because without card reader, Adeleke couldn't have emerged. I don't believe he would have emerged. Looking at the political climate, card reader is the best thing that has happened. PVC and card reader is the best thing that has happened to the electoral process.
But why can't Adeleke emerge if the people decide so?
No, the point I'm making is that without smart card reader, the government in power has an advantage to manipulate the process. But with card reader, it is increasingly difficult for people to storm a polling unit with talks aided by compromised security agencies, hijack the ballot papers, sit down somewhere and begin to thumbprint. You no longer have that, which is why we now have, you know, the notoriety of vote buying. They now have to resort to monetary inducement. So when INEC is now insisting, because you are aware the Supreme Court has said in the case of Amechi, and of course we don't Emmanuel, my own state, and even other cases, that yes, card reader is commendable, but failure to use card reader cannot nullify election. INEC has basically, by administrative policy, subverted the decision of the Supreme Court, in that when card reader does not function, rather than resort to manual accreditation, INEC postponed the election. I commend the Commission, because if that does not happen, you have a situation where, for example, in those 2 polling units, People could have just taken the election materials, sit down somewhere and thumbprint, and there would have been a difference in the vote.
You made mention earlier that resolving this issue is a legislative matter. We have an amendment to the Electoral Act that has been going back and forth between the executive and the legislative. How can this be resolved? How can we put all of this together and ensure that there is a working legal framework with which INEC can operate with?
It is unfortunate that the Saraki-led Senate and the Dogara-led House of Representatives have not prioritized the need to sanitize the electoral process. And I say that with all sense of responsibility. Some of us have been very adamant in a position that the executive is not committed to the digitalization of the electoral process by giving legislative backing to the use of the car reader when the president vetoed the bill. Only for information to even come out that car reader was not even part of the bill submitted to the president. As a Nigerian, I felt seriously scandalized that you have a National Assembly that is now effectively led by the opposition, not appreciating the importance of giving legislative backing to the reform of the electoral process. And you now have the Senate continuously postponing their resumption when we have few months to election. This is an opportunity for them to even address, looking at the fallout from Osun, to go back, sit down at the National Assembly, and give a national importance to what has happened. The Electoral Act has to be amended. The Constitution has to be amended to improve our electoral process. The politicians on their part are extremely reluctant to do what is right. That is why we need the law to clarify and also make this issue certain. Right. Because until the National Assembly intervenes, there is very little that INEC can do. That is why INEC has to resort to manual in the first place. Okay. If the law was clear, INEC would not have issued the guidelines.
All right. Some persons have said that even though the National Assembly is saddled with the responsibility of making laws, but originally it is the nest of politicians and politics. But going away from there back into the legal issue, PDP has said that they are going to court over the Osun inconclusive election declared by INEC. What would be that implication? If they go to court now, which is just in less than 48 hours.
No, they can't go to court now.
Okay.
They cannot. No court can. There will be no basis to go to court. By virtue of section 285 of the Constitution.
Why not?
It is an election issue. It's not a pre-election issue. Okay. By virtue of section 285 of the Constitution, only a tribunal can entertain an election matter. There is no tribunal for Osun State. Tribunal can only be empaneled by the President of the Court of Appeal when the election is concluded. We don't have a tribunal. So which court are they going to go? They have to wait for the election to be concluded on the 27th. They can now ventilate their grievance at the tribunal, if supposing there is any merit anywhere. But as that today, there is no court. To hear them, there is no forum. They cannot approach the Federal High Court because it is not a pre-election matter. It is an issue arising from the conduct of election, which only the tribunal has an exclusive jurisdiction on. So when they say they are going to court, they are just playing to the gallery. My advice to them, as I have said earlier, is that let them prepare for the supplementary election or the rerun election and put in their best. But to begin to resort to these legal niceties in view of the decision in a delicate case, for me, it's neither here nor there.
What's the implication of having elections won at the courts? Because it appears all of our elections eventually
many of our courts have been decided.
Ekiti, for instance, is in the tribunal.
Nobody wins at the courts. I have said it as a lawyer, and I stand to be corrected. I've challenged anybody to correct me. Right. That since the jurisdiction in gubernatorial election petition, the appellate jurisdiction was extended to the Supreme Court upon the amendment of the Constitution. It used to end at the Court of Appeal, the Salami era, before it was now extended to the Supreme Court. No election has been nullified by the Supreme Court of Nigeria. I am not saying the Supreme Court is doing anything wrongly. I'm just saying that by judicial precedence.
But we have had situations where when elections held, winner emerged, and then after going to court for several years, it happened in Osun. That's why elections are holding this year.
What I'm saying is that show me one example where a governorship candidate went to the Supreme Court and the election was nullified. All the petitions that have gone to the Supreme Court have been validated. All. So when people say they are going to court, I appreciate them. There is no alternative. The election is won at the polling unit. So let us focus on doing things right. Because at the end of the day, there are precedents clearly showing that some of these things they are saying they want to go to court to ventilate may not really be of help to them. So it is better for the politicians to do what is right in the field. They have the right to go to court. Okay. It's a constitutional right.
All right.
But I'm saying that how much can they get from that exercise.
All right. We have to leave it here now. They have the right to go to court, like you said. In fact, if your father slaps you and you're not comfortable, go to court. The court is the best place to handle any. Invalid, thank you so much for coming on the podcast.
Apparently, I can tell you that this conversation is conclusive, just like the Osun election. I mean, the conversation is on.
Well, the conversation will be on. The most important thing is getting clarity when it comes to the books, what the principles say, what the guidelines say, and all of that. And certainly, by now, people are getting more enlightened as to what the books are saying, what the regulations and rules guiding the elections are saying. We must thank all our gentlemen for coming on the program.